Assalamu alaikum. Today we will discuss what is mediation and what are different stages of mediation. Mediation is essentially a search for a solution by the parties to the dispute themselves under the guidance of a third party. Mediation is an informal process in which a trained mediator assists the parties to reach a negotiated settlement. Mediation may be thought of as assisted negotiation. In negotiation, basically parties themselves resolve the dispute by negotiation by suggesting different alternatives to resolve the dispute, and if the party hire a third person, hire a third neutral to assist them in resolution of dispute, then this is called mediation. Basically, it is a negotiation assisted by a third person known as mediator. The mediator does not decide who is right or wrong or has no authority to impose a settlement on the parties. Instead, the mediator helps the parties to jointly explore and reconcile their differences. In mediation, it is more for the parties than for the mediator to settle the problem. The parties to the dispute need to be aware of various issues, such as details of the case. In the context of appearing for the mediation session, know your case means knowing and preparing the following elements: facts which are disputed and facts which are not disputed, facts which are critical and important, details of cause of actions and facts of the case, the damages the client may suffer or other relief desired. As a defendant or claimant, parties should first know what they really want. This will help the parties to focus on what they hope to achieve in mediation. Second thing is counterclaim and defenses. If the party is actively resisting the relief sought by the other, he should know the possible counterclaims and defenses, the liability issues, disputed and undisputed. So, firstly, the parties should know what are the details of the case and what are possible defenses and counterclaims made by the other party. Then, the parties should know the awareness of alternatives to settlement. A perfect comparative picture can be arrived only after finding out the alternative so that a right choice is suggested and accepted. After knowing the details of case, counterclaims, and awareness of alternatives, parties should also have awareness about the risks. The risks, which are the alternatives in the case the parties do not settle, the cost of going to trial and the delay involved in the same, the risk of potential outcome in case the alternative of trial is adopted. Be aware of the opposite party's option, if any, in case the mediation fails. Now, the role of mediator comes here. The mediator is like a team leader who has to make the parties to the dispute aware about the alternatives available to them as well as about the dispute. Mediator has to explain the mechanics of the system so that the clients understand the procedure and keep them from being surprised by the process. The mediator should explain the fact as the law sees them so that the client understands that what matters are not the facts but the admissible evidence. This helps client avoid trouble later. Mediator should explain the law as the state has created it so that the clients understand that the result they will get will not necessarily be what they think is fair but what the laws allowed. Mediator update the status of the case so to help the client understand how much or how little time settlement can save. After preparing for mediation, the mediation start, which has the following stages. First stage is coming together of necessitating parties. Second stage is discovering all the facts of the case. Third stage is collection of pre-mediation briefs. Fourth stage, consideration of evidences and witnesses, corroboration of the same. Fifth stage, continuous effort by mediator in convincing the reluctant party to agree for resolution. Sixth and the final stage is consolidating the gains of mediation into agreed settlement and follow up till the parties realize the result.